All right, please be seated. Please give your attention to Mr. Diaz. He's going to deliver the closing argument for the state.
Thank you, Your Honor. If it please the court, ladies and gentlemen of the jury, Mrs. Cox, Mr. Cox, Cox family. This will be the only and final time that you hear from the state in this matter until we have the opportunity to talk to you after you've come back with whatever decision you're going to be making. Now, we would all recognize that we've been on a very long road together here, started back in February. And all this time in order to address a very tragic incident, one which most of us will never forget, one that was not foreseen by the state. Now, why do I say that? And I say that because of what is occurring is what we refer to, and you've heard throughout the trial at various stages, hindsight biased, armchair quarterbacking, second guessing. You've heard throughout from the very beginning an opening statement, spinning of what the actual evidence and facts is in this case. There's no ifs, ands, or buts that it was a very tragic matter. But the state, and we're going to show you in a moment, that the state took this very serious. They did their job, they followed their policies. And what we're going to ask of you is to evaluate this case based upon the information that was known at the time, and that the state's reliance upon professional evaluators, a knowledgeable court, a judge who was overseeing these proceedings. Now, as the trier of fact in this case, 12 of you will be making a decision that all of us will be living with as this chapter of the Josh Powell legacy comes to an end. As the trier of fact, the judge has instructed you on the law, state's duty that was owed to Charles and Braden, a duty of a reasonable person using ordinary care to protect them from foreseeable harms. It is easy to get lost in the horrible loss of these two beautiful little boys. And only comfort is the fact, as Dr. Clifford Nelson testified here just recently, that the boys fortunately did not suffer as they were unconscious from the initial blows that they suffered at the hands of their own father. A person that these boys loved, trusted, and wanted to be with. And we heard plenty of testimony of that fact from people that had direct contact with these boys. Now, it's important to note that multiple eyes were not only on the boys during the time that they were in the dependency action, but also on Josh Powell during this time period when the state was involved in their lives. Prior to the dependency, only law enforcement was involved, and their focus was upon Mr. Powell concerning the disappearance of his wife. But after more than 2 years after her disappearance, still no arrest, no charges against Josh Powell. A man who had no known criminal adult history, a man who was fully employed, a man who was not a substance abuser, a man who had been educated, a man who was providing for his sons when they were taken from him and put into the state's care and custody due to the actions of his own father, Stephen Powell. Now, what I'd like to do is walk you through the timeline of the state's involvement in this matter to help refresh your memory, because it has been many months, many witnesses. The state tried to bring in the witnesses who were directly involved during the time period so you could hear from them, you could see them, you could ask your own questions of them, which you did. Now, what I like to do, it will go to the first slide. In this first slide, and I just moved it We can go back one, please. So the first involvement that the state had any knowledge concerned shortly after the disappearance of Susan Cox-Powell in early December of 2009 in West Valley City, Utah. And that it became known that Mr. Powell had moved and relocated from Utah to Washington State with his sons, Charles and Braden. And that he then moved into his father's residence in Puyallup. Now, until Susan's disappearance, there was no known prior history with law enforcement in the state of Utah. And it was known that the Powells also had no prior history with child protective services in Utah, no recorded history of domestic violence or child abuse. We heard from West Valley Police Detective Ellis Maxwell, who testified here just a short while ago, sometime, I believe it was even last week, that he was not aware of any child abuse or sex abuse while Charles and Braden lived in Utah. We can go to the next slide. Next slide, please. So what we have, when the boys came into the state custody, we had law enforcement originally, shortly after the Josh Powell and the boys came to Washington, had applied for a sealed search warrant to go into the Powell residence, a warrant that was not available to DSHS, or as I'll refer to them, throughout the department. And then a search was conducted on August 25 of 2011, which eventually there was uncovered images that belonged to Stephen Powell, which depicted child pornography and voyeurism. Pierce County Sheriff decided not to place the boys in protective custody at the time the search was conducted. And you heard the testimony from Detective Sergeant Sanders, also Detective Sergeant Teresa Berg. And they had described at one point a house of horrors that they observed back in August when they assisted West Valley City, Utah police in a search of Stephen Powell's residence. But they did nothing about the boys at that point in time. It wasn't until a month later, September 22nd of 2011, Stephen Powell was arrested. And law enforcement came to DSHS and the department, told of their plan to arrest Stephen Powell, and that they wanted to place these boys then into protective custody. And that's how the state became involved. A number of people over the course of several months, starting in September through or until early February, actually, had involvement. We've listed it, a number of the people here for you. Forrest Jacobson, master's degree in social work, who at that point in time had 10 years of experience when she was involved in this matter. Rocky Stevenson, 20 years of experience in social work. Betsy Rogers, 20 plus years. Julie Slaughter, 23 years of social work. And then we had other people that were providing services to the boys. Lori Narigi, who provided mental health counseling for the boys shortly after they were put into an out-of-home placement with the Coxes, but during the course of the dependency and services that were provided. We had Michelle Breland, who testified, who is associated with the Child Abuse Center here at Mary Bridge Hospital, who examined the boys upon coming into custody of the state for purposes of evaluating for sex abuse and also physical abuse of the boys. You heard her testify that there were no signs based on her examination of those boys that would show that there had been active abuse, whether physical or sexual, of either boy. As she advised you, though, they can never rule anything out, but there is no history or facts that would support any prior sex abuse or physical abuse of the boys. We also had testimony from Paula Strickland, another master's level social worker, therapist, who provided services for the boys with their transition into the Cox household. And she was providing services for both the boys and for the Coxes, and she did so for 3.5 months. Elizabeth Griffin Hall, I heard just ending the plaintiff's first part of their opening, which they'll have another opportunity to come back to rebut everything that I'm about to tell you, and I'm certain they probably will. But Elizabeth Griffin Hall, you could hear in her voice the shock, the terror, the unknown of what was occurring. She had not experienced anything like that. That was her 11th visit on that day to Josh Powell's residence for a supervised visitation. Over the course of the dependency action, there was more than 20 supervised visitations, and a majority of them were conducted by Elizabeth Griffin Hall. We had a handful of visitations supervised by Pastor Tim Atkins, which occurred in his residence as visitations had, through natural progression in this type of a dependency matter, they had increased over time. Then we had Dr. Manley, who at the time of his evaluation had 12 plus years of doing evaluations. You heard him testify that many of the evaluations in the past that he did were for competency of people with mental disease or mental illness or sex offenders. We had Dr. Whitehill, who testified in this case, who had 30 plus years, who also testified about his association in dealing and treating and evaluating sex offenders and people who are accused of crimes. Julio Serrano, who was assigned by the dependency court as a guardian ad litem, and he had testified that he had 17 years of experience. He was appointed by the court as a special advocate for these boys. Now, we're going to go through more information here, but as the plaintiffs have been claiming that none of these people knew what was occurring, and that is just not true. You'll see and have the opportunity, and I'm going to actually encourage you not to rely just on what notes you've taken over the course of, I believe today's 31 of our trial. And over the course of this trial, you've taken notes. But I want you to also look at the exhibits. And I'm going to go through a list of those exhibits that you really need to pay attention to. You need to be able to put it in all of the facts that you've heard over these many weeks into the proper context of what was occurring and when. Now, I'm going to recite or show you the very first time that we were aware of anything. That was on March 1st of 2010, when there was a referral, a call-in from someone in the state of Utah who was claiming that there was people in Utah that were abusing Josh Powell. That referral was not screened in, but you've heard throughout this course of the many weeks that, well, the department never investigated. They had all of these opportunities. They had these prior referrals. And you'll have the opportunity to read those referrals. Those are all exhibits that have been admitted in this case. But you also heard the testimony from Julie Slaughter, who was an intake supervisor, why they weren't screened in. They didn't meet the criteria. The department has to follow various regulations and laws as to what they're able to do and not able to do. So March 1st came in, but then also in March, the next time we had a situation which only John Long was aware of. The department was not. But in March of 2010, he testified that Detective Sergeant Teresa Berg of the Pierce County Sheriff's Department had contacted him to inform him that they were seeking a warrant in order to go pick up Charles and Braden, take them from his father, and for the purposes of interviewing them to see what they knew about their mother's disappearance. And that based on what was disclosed, that those boys may potentially be put into protective custody then. That was in March of 2010. We heard from Detective Berg, and we heard from others, including Detective Sergeant Gary Sanders, that after spending an entire day with those boys, interviewing the boys, they returned them right back to their father. And we've heard that, look at the risk. The state should have known of the risk, because if they witnessed something and they started to disclose something, well, their father, he might take out some retribution, he might take out revenge, he might do something to those boys. But what did law enforcement do? They returned him. They returned him back to their father. So March 10th was the date of the actual interview, and nothing was done at that time. The state was not contacted to be advised on what the result was of those interviews. Then we have a second referral to DSHS or CPS in the department, August 20th. Now, you've heard these facts over and over and over again. It's because it's very odd, but it doesn't rise to the level of abuse or neglect for CPS to open an investigation. This is where the YMCA had advised and called up to state that Charlie said, when you kill a bear, you dig a hole. You bury the bear in a hole, you cover it up, plant a tree on it, some raspberries. Very odd for a child at that point in time who's 5 years old. Now, we have to recall that when their mother went and disappeared in December of 2009, these were 2-year-old and 4-year-old boys. We then look at this referral that came in, and what did the department do? They referred it on to law enforcement, which was the appropriate entity to have this information in case it had some importance. And at this point in time, they were aware that Susan Powell had disappeared. They were aware of the importance that this information might have for law enforcement. But the department and CPS, they are not law enforcement agents. They don't have the power to go out of state and do investigations. That's important. And they don't interfere in criminal investigations. The last thing that they wish to do is interfere with an ongoing investigation, which could be detrimental to that investigation. So after passing on the information, in fact, West Valley City Police came out to interview the staff at the YMCA. And while they were here, they then contacted CPS to advise that there really wasn't anything to this burying the bear and planting a tree on it. But they requests if we got more information, if we would share that with them. And this is important because we've been accused of not doing our jobs. We've been accused of not cooperating with law enforcement, not cooperating with others. And there's nothing further from the truth. And that's why I want you to hold us to and review all of this information so you get a clear picture. Because what you keep receiving is the spin that has been going on for quite some time now. September 9th, Detective former detective, he's now retired, Ellis Maxwell, calls DSHS to advise that they had interviewed the staff, there would be no follow-up, and again, makes the request if we would advise them if there's anything that could potentially be of interest in their investigation. The first several exhibits that you're going to see when they come back to you, and many of the exhibits are judicial assistant to the judge has placed these exhibits in three-ring binders. So the very first 3, 4, and actually the first 5 are going to be these intake referrals. Now we're going to move on to the year 2011. And that's the next referral, the third one that had come in from the state or into the state. This was also screened out, but this is where, again, at Charlie's school, he had indicated that his little brother was gone, that he'd been killed. That is not the type of a call to CPS that they have authority to go and open up and screen and do an investigation. What they do and what they did here was they called law enforcement. The Pierce County Sheriff's Department did a welfare check. They went out to the residence, Stephen Powell's residence, where the family was residing at the time, and Braden was there. And so they had reported back that everything was fine. We have a fourth referral that came in on June 10th. Again, Charlie making statements about not liking people, not believing in Jesus, bad things about the Mormons. And once again, there was no accusation or complaint of child abuse or neglect. And the department, once more, referred it to law enforcement to investigate as to any significance or importance that it may hold. And in fact, former Detective Maxwell came out to Washington State once more, and he met with Julie Slaughter and addressed that concerns they may have regarding the household and whether or not CPS could accompany them to do a welfare check. And they were advised, without an active case, we don't have authority to go to people's homes. Law enforcement has the authority to. They were working hand in hand, as you heard from Detective Sanders, who got assigned as a liaison with the West Valley Police Department early on in their investigation. He had actually testified that he was first contacted in December of 2009, but it was in January 2010 that he began working closely with the West Valley Police Department. We move on to September 21 of 2011, and there was a meeting. And this meeting occurred after the search of the house, which we had mentioned earlier in August, which then led to the boys being placed into protective custody. When the boys were put into protective custody, we have several slides of information regarding what the known risk factors in this case were. And we have from the testimony that you heard on July 15th from Detective Sergeant Teresa Berg, where she testified about the known risk factors at the time, and how she said it's easy if you have something concrete like an injury or a sexual assault. It's very difficult to show potential risk in these situations where you might think something is going to happen, but you don't have enough proof to remove a child. It actually takes facts and proof to remove a child from their parent, to keep them out of the home. You can feel like there is risk, or you can sense there is risk, but gut feelings don't count. We have to have facts, and that was difficult in this case. And that's been difficult throughout the life of this case for the department at the time that they were dealing with Charles and Braden and Josh Powell. We also had heard that from Detective Bird, she claims that prior to the boys being placed into protective custody, she had told at a meeting Rocky Stevenson, Assistant Attorney General Long, she believes that Betsy Rogers may have been present, Billy Reed Litsky, that she thought Josh Powell was going to kill his sons. But she had no facts. She had no evidence. So on September 22nd, 2011, a complaint was filed with CPS. That's Exhibit 5. And that was screened in since the boys had been placed into protective custody. Anytime children are placed into protective custody, that will be a screened-in event. They were taken into protective custody back in March of 2010. They were taken into protective custody when the detectives were searching the House of Horrors at Stephen Powell's residence in August of 2011. And it wasn't until they discovered child porn and voyeurism photographs that were in the computers of Stephen Powell. No accusation, no facts that there was domestic violence going on within the home. There was no facts of domestic violence known then or after that the department never learned of. Yes, the fact that Susan Powell was missing was known, but again, we need more than just supposition. So what we have here on this slide is once the boys in the meeting occurred, what happened in the life of the CPS and the dependency over the course of several months. So you'll see that there was that meeting we've discussed on the 21st of September. The 22nd of September, the boys are put into protective custody. On the 23rd of September, there was a meeting at the Advocacy Center, the CAC, which you've heard those initials, where there again was no information regarding some known threat that these detectives thought there might be. We have a symbol for law enforcement, and we'll show you a slide a little later, which actually shows the contacts that the department had with law enforcement over the life of this dependency. We also too know that there were several proceedings that were commenced, because on the 23rd of September, Mr. and Mrs. Cox filed in the family court here in the Pierce County Superior Court a non-parental custody action seeking the custody of Charles and Braden the day after the boys were put into protective custody. You heard testimony throughout the trial from not only their attorney at the time, Steve Downing, but also Mr. Cox and Jennifer Graves about what they alerted the Superior Court judge of regarding the facts that they had concerning the risk of harm, any past abuse, everything that they would want to utilize in order to support their action to remove those boys from their father's custody. And what was there? There was a hearing on the 27th of September, at which time Judge Catherine Nelson, presiding, who had before her a 10-page declaration from Chuck Cox. She had the motion from Mr. Downing. She had a hearing where Mr. Downing spoke. We had a hearing where Mr. Downing told the judge of various facts, including Braden telling his aunt, his great aunt, sometime earlier in time, that Braden pointed at a picture, the chest of a person in a bathing suit, and said, "Mommy owie. Mommy owie." Information that Judge Catherine Nelson was fully aware of. And through the course of the hearing, and we also had present at that hearing as a courtesy, Assistant Attorney General Long, who advised you that during the course of that hearing, not only did Judge Nelson ask for additional information, which Mr. Downing said he would retrieve, but that what information that Mr. Long had regarding the criminal charges against Stephen Powell was given to the judge. That was shared with her. What's important about these facts? The importance is that the very next day, when the dependency action commenced and there was a hearing, Judge Nelson already had a wealth of knowledge regarding not only the Stephen Powell residence, but facts surrounding the disappearance of Susan Powell and accusations that were in the declaration that Mr. Cox had filed, that he believed that Mr. Powell was the only person responsible for her disappearance. So we have a person presiding over proceedings who has information regarding the risk factors that may be involved and the threats that may be involved as decisions are going to be made regarding the boys. So the following day, on the 28th of September, there is a hearing now because the state had filed a dependency petition on behalf of Charles and Braden. And at that hearing, the judge ordered what we refer to as an out-of-home placement with a relative placement. They were placed with the Coxes, Charles and Braden. Also, at that time, the department requested and services were commenced. We had mentioned several of the people that were involved in services, but there was also health and welfare check. We had heard over time the acronym CHET, C-H-E-T. Social worker was assigned to go and evaluate the boys' medical needs, dental needs, their educational status, so the state could start providing services to address any of those needs. It was also determined that the boys could benefit from mental health counseling, and that was all arranged and began in the month of October with the mental health counseling. Also, on the September the 26th, we did have the medical examination that Ms. Breland had testified to here a week or so ago. The department takes serious anytime a child is put into its care and custody. Moving on to the month of October, visitations which were ordered at the shelter care hearing, which was on September the 28th, commenced. the green symbols indicate supervised visitations. They occurred on Sundays as the court had ordered in order to not to interfere with the Cox's church services, which they would attend. And so that's what the order indicated, was that it would be services during that time. But during this time, we are still having contact with law enforcement. And we've got on here weekly meetings that were occurring at the ACA, the Child Advocacy Center, which Detective Sergeant Sanders would attend. An opportunity to have open dialogue based on current cases that are here in Pierce County. I want you to look at what we refer to as case notes. Those case notes are Exhibit 55. In Exhibit 55, you'll find the notes from Rocky Stevenson, you'll find the notes from Forrest Jacobson, you'll find the notes from their supervisors, you'll even find the notes from Julie Slaughter that go back to these earlier referrals in 2010 and earlier in 2011. I'd like to have you read those. I'd like to have you see what information that was relayed to them, what they include in those notes. You'll actually see in Rocky Stevenson's notes his interview with Jennifer Graves and her husband Kirk Graves that was out at the Cox residence. You can see for yourself, and we're told that, well, there's a cover-up, hiding things. What are we hiding in September? Really, what is being hidden by the department? As they're trying to figure out and get assistance by whatever means they're able to without interfering with now 2 active criminal investigations. You'll go, and when you look at the petition that was filed for this dependency, there was 11 allegations. Yes, the last one talked about Mr. Powell being a suspect in the disappearance of his wife. But you'll look at those other allegations, all concern the household that they were removed from and the criminal charges against Stephen Powell. So you'll see from this calendar the various referrals that took place, various visits that took place. And you'll see even the notes in Exhibit 55 from the check worker, Ms. Saravino, and the results of her examination, the recommendations that were being made for medical checkups, dental work for the boys. The department takes their work serious. We have also, in October, other activities that are taking place. Mr. Powell volunteered to have a psychological evaluation with a parenting component at the shelter care hearing on September 28th. The court went ahead and put that into the order. And I would encourage you to look at each of these orders. They're important. There's information contained in each one of them. So here on the 14th of October, Forrest Jacobson, she prepared a referral to Dr. James Manley only after an attorney had appeared for Mr. Powell, Jeffrey Bassett. And you'll find emails which are part of Exhibit 270A. And I'll ask you to read those emails. But as part of that, you'll see that Mr. Bassett had a say in who was selected to perform this psychological evaluation on Mr. Powell. It was not a unilateral decision made by Forrest Jacobson or the department. But if you recall, many months ago now, Jane Raymond, her red flags, the department provided no information to Dr. Manley. We didn't give them any records. We didn't provide any updates. We didn't do jack. If you remember when Forrest Jacobson first got on the witness stand and I had an opportunity to question her, first thing I did was again show this referral letter, exhibit number 17. It outlined all types of information that had been supplied to Dr. Manley, including a recent 300 and some odd pages of Josh Powell's parents' divorce records from 1992. Information that was sent to Dr. Manley, so as he would go into and perform his psychological evaluation, he would have important details about the history of the Powell household back in the early 90s, and in fact, information about Josh Powell. That wasn't hidden. That wasn't buried. In fact, Dr. Manley testified that when he received the documentation, there was actually Post-it notes that Ms. Jacobson had placed on him to direct him so he didn't have to go through 300 pages if he didn't desire to, that pinpointed various accusations that involved Josh Powell. And so if you recall, when he went through what Ms. Jacobson had tagged when she testified, he confirmed that, yes, I received that information. But look at the referral letter that was sent. It included the dependency information. It included the non-parental custody information, the action that Mr. Cox has supplied a 10-page declaration. If you remember, when I asked Mr. Cox on cross-examination, would you please point out in this 10 pages, the information you gave to Judge Nelson, important information because you want the custody of your grandsons. Will you point out in this declaration where you allege any form of violence within the Josh and Susan Powell home? I ask you to look at the same because it's not there. It's not there. Josh's sister, Jennifer Graves, came into this courtroom and testified to you. And she said, well, I told Rocky all of this information about how I believe that Josh was assaulting his wife. That's not in Rocky's records. Look at it. Again, it's in Exhibit 55. Notes that were contemporaneous. Those notes were taken on September the 29th, 2011. They're there for you to review. But more importantly, Jennifer testified about all of the concerns she had and what she told Rocky and what she'd been telling people. What she failed to tell you that she also filed a declaration in that non-parental custody action on September the 28th of 2011. It included zero information about any physical violence within the Josh and Susan Powell home. I asked her to please point it out for us. It's important. We had Mr. Downing again at that hearing on September the 27th in front of Judge Nelson. She pressed him, what is the imminent harm, the facts that support that claim on these boys? The only thing he could come up with, their mother's is disappeared. She's gone. We suspect Josh Powell's done it. And Mommy Owie. Judge Nelson was fully aware of that. She was fully aware of it the next day when the department filed for dependency and there was a hearing. She was fully aware of that when she ordered visitation visitation that would be supervised. And in fact, it was supervised. The highest level of visitation that the department has. Now, we have a lot of argument that's gone on that, well, the department should have had a secured environment. You heard from every witness who testified about the security, whether it was at a DSHS office. They said that, yes, there's a security guard at the entrance, but they don't screen people in. If something happens, they're told to let them flee. That's not security. We had testimony from Julio Solano. We had testimony from Dr. Manley on visits they had at the Foster Care Resource Network. That it's an old house. Their security is a home alarm system, the same thing that many of you have into your own residence. That people are free to come in, they're free to leave, but we had to have it at a secure environment according to the plaintiffs. Visitations were discussed on transitioning to Mr. Powell's home, which you heard from Julio Solano, again, the guardian ad litem, the natural progression. The natural progression that one would see in a dependency action. And that preferable, and the guides on visitation shows the number one preferred location is at a parent's home. Why is that? They testified it's because that way the children feel the most comfortable. It's an environment where they have their own belongings, where they feel like this is where I belong. That's why transition to a home occurs. In order not to keep these boys in an environment that they're not used to, that's strange, but for comfort level, as again, their needs are being looked at and taken care of. Now, we had conversations or testimony regarding Nancy LeMay and how that was totally, basically blown off. Nancy LeMay actually spoke with Forrest Jacobson on October the 14th of 2011. And just to remind you, this was part of the Rock Club incident. Ms. LeMay actually, even after talking to Ms. Jacobson, sent a lengthy email. Read the email. It's there. It's an admitted exhibit. Again, it's all part of Exhibit 270A and 270B. Both are many of the most important emails throughout the life of this case. But what did Ms. Jacobson do with this information? She passed it on to Dr. Manley. She passed it on for purposes of his evaluation. And in fact, in exhibit number 18, which is Dr. Manley's December 2011 report, he talks about it. It's in there, it's included, along with a lot of other details. And what was the purpose of the evaluation report? It wasn't just for the department's information. That report was given to Judge Nelson, who happened to take concurrent jurisdiction, not only over the non-parental custody action, but also then over the dependency action. A person that had a wealth of information, even more so than what the department had in the early stages of this case, because of what the Coxes had provided to her already before the dependency even began. And then the information that was then provided through these different evaluators, these different professionals, these different people had eyes on these children and eyes on Mr. Powell. But here in mid-October, we have another person involved in the Mr. Powell's attorney, Jeffrey Bassett. We also had on October the 17th, the Family Preservation Services, the counseling within the Cox home commenced with Paula Strickland. We have monthly Forrest Jacobson going into the Cox residence to do what was called a health and welfare check, where she would go in and meet with the Coxes and then meet individually with Charles and Braden to find out how they're doing, if they have any concerns. That's, again, all part of her case notes. I encourage you to read those. It's all part of exhibit number 55. But the important fact that took place was on the 26th of October. Initially, at the shelter care hearing, there was a hearing scheduled, a status hearing for mid-November. And that status hearing would have been before Judge Nelson. But once Attorney Bassett became involved, he contacted the department and advised that Mr. Powell would agree to a dependency. So there was a hearing that was conducted on the 26th of October, 2011. An order that was also entered at that date, which just reaffirmed that Mr. Powell would undergo the psychological evaluation with a parenting component, which we heard testimony is the typical type of evaluation that is done in these types of cases. Not like Dr. Adler testified that we're dealing with some form of dispute in a dissolution, child custody, where he gets involved and will evaluate for purposes of one parent or the other. This was a different form of evaluation, which is Dr. Manley has testified about at length. At that time, on October the 26th, and we heard testimony from Mr. Long that, in fact, Mr. Bassett told Judge Nelson that Mr. Powell had obtained his own residence, that he removed himself from his father's residence, that he wanted to separate from his father in order to have his own home so that his sons could be reunited with him. The goal in these type of cases is always family reunification. That remained the goal throughout the history of this dependency action. But there was no rush at any time to dismiss the dependency. There was no rush to reunify without having all of the input from the professionals who were involved. And in fact, later on, you'll see that Forrest Jacobson, even prior to seeing any of these images that were subsequently provided by the state of Utah, filed a declaration with the dependency court asking Judge Nelson not to allow reunification. Not to allow reunification. We also heard that from Detective Sergeant Berg that she and Detective Sanders many times would attend these hearings. But she admitted at no time did she approach the people that she had worked closely with for years, including Assistant Attorney General Long, to advise anything about your gut feeling. But more importantly, whatever information that Detective Sergeant Sanders had, and at this point we're reaching out to West Valley City Police asking for information that would assist the department in its dependency. We were even sharing information with them that really the department is on thin ice here because Mr. Powell is complying with what the court is ordering. The allegations believe that he may have had some involvement in the activities in his father's home, but there was no evidence coming forth to show that. We had his attorney pressing the department that this needed to be concluded. And the department is trying to delay and put off Mr. Bassett and Mr. Powell for time to learn more information and details. Now, we heard from former Detective Maxwell. If you remember, I asked him a question that at no time during the course of the dependency action in the state of Washington did you provide any information as to past sex abuse or child abuse that you were aware of in the state of Utah to the state of Washington. He said that was correct. Now, we've heard from plaintiffs throughout this case that this is a domestic violence matter. We heard testimony from Judy Slaughter that when this came in, there was no one in the Stephen Powell residence where there was any accusation whatsoever of domestic violence. Who had the most information at that point in time of anyone? Detective Maxwell, lead investigator in Susan Powell's disappearance. The dependency action was commenced more than 21 months after her disappearance. It's reasonable for the department to ask the law enforcement agency to share information that would be relevant here in our state in their investigation. But once again, Rocky Stevenson and other social workers, their job is not to interfere and go out and start interviewing people out of state and interfering with a pending and active criminal investigation. So they're relying on who had the most information at this point in time. They've been involved in this investigation for over 21 months. And in fact, on the date that these little boys were killed by their father, still hadn't acted. More than 2 years later, almost 26 months. But the next question I asked Detective Maxwell, during the course of any contact that you may have had with Assistant Attorney General Long, when he spoke with you or communicated by email with you, was he requesting information for any evidence that you could share for the dependency action that he was involved in here in Washington State in order to provide it to our court concerning the safety of the boys? He affirmed that yes, that was being asked.
All right, Mr. Diaz, I think we'll take our afternoon recess for 15 minutes. Ladies and gentlemen, put your notepads down on the pews. Go with Kylie across the hall. I'm going to stay on the bench for just a minute to chat with the lawyers, and we'll see you in about 15 minutes.